Question 1. The evaluation methodology shows that an applicant for a Category H firearm license in the Australian Capital Territory has disclosed a history of domestic disputes, including one occasion where police attended their residence, though no charges were laid. Which of the following risk assessment approaches best aligns with the regulatory framework for firearm licensing in the ACT? Option A. Accept the applicant's declaration at face value and proceed with the license application, as no criminal charges were laid. Option B. Consider the domestic disputes irrelevant to the firearm license application, as they did not result in a criminal conviction. Option C. Actively seek further information from ACT police regarding the domestic dispute, review any associated court orders or apprehended violence orders, and consider the need for a psychological assessment to determine the applicant's suitability. Option D. Immediately deny the license application based on the mention of domestic disputes, as this indicates a potential risk. The correct answer is C. Actively seek further information from ACT police regarding the domestic dispute, review any associated court orders or apprehended violence orders, and consider the need for a psychological assessment to determine the applicant's suitability. Explanation. The evaluation methodology shows that a Category H firearm license applicant in the Australian Capital Territory, ACT, has declared a history of domestic disputes, including one instance where police were called to the residence. This scenario is professionally challenging because it requires balancing the applicant's right to apply for a license with the paramount public safety considerations mandated by ACT firearm legislation. The applicant's history raises significant concerns regarding their suitability to possess a firearm, necessitating a thorough risk assessment that goes beyond a simple check of criminal convictions. The best approach involves a comprehensive risk assessment that actively seeks further information regarding the domestic disputes. This includes contacting the ACT police to obtain details of the incident. Reviewing any associated court orders or apprehended violence orders, AVO, and potentially requesting a psychological assessment if deemed necessary by the licensing authority. This proactive information gathering is crucial for determining if the applicant poses an unacceptable risk to themselves or others, as required by Section 31 of the Firearms Act 1996 Act and the associated regulations concerning suitability. The ACT Firearms Registry has a duty of care to ensure that licenses are only issued to individuals who are fit and proper persons, and this requires a detailed examination of any factors that might indicate a propensity for violence or a lack of judgment in handling firearms. An approach that relies solely on the applicant's self-declaration without further investigation is professionally unacceptable. Failure to conduct due diligence would contravene the ACT's legislative intent to prevent firearms from falling into the wrong hands. Similarly, an approach that dismisses the domestic disputes as irrelevant because no charges were laid or convictions recorded would be a significant ethical and regulatory failure. The legislation does not limit suitability assessments to only those with criminal convictions. It requires consideration of any information that suggests the applicant may be a risk. Ignoring such information would abdicate the responsibility to protect the community. An approach that immediately denies the license based on the declaration alone, without a proper assessment process, would also be flawed, as it bypasses the procedural fairness expected in licensing decisions and fails to gather all necessary information to make an informed judgment. Professionals in this situation should employ a structured decision-making framework that prioritizes evidence-based assessment. This involves understanding the legislative requirements for suitability, identifying potential risk factors, systematically gathering all relevant information, including from external agencies, objectively evaluating the gathered information against the legislative criteria, and documenting the entire process and the rationale for the final decision. Question 2. The risk matrix shows a moderate likelihood of unauthorized access to a Category H firearm if stored in a standard gun safe within a home environment in the Australian Capital Territory. What is the most responsible and legally compliant approach for the licensee to manage this identified risk? Option A. Delegate the responsibility for ensuring the gun safe is always secured to another adult household member without verifying their understanding of safe storage protocols. Option B. Assume that because the firearm is rarely used, the risk of unauthorized access is minimal and requires no further action. Option C. Rely solely on the minimum legal storage requirements for the gun safe as stipulated by the Firearms Act 1996 Act, assuming this is sufficient. Option D. Conduct a detailed, documented risk assessment considering household demographics, access points, and implement enhanced security measures beyond the minimum legal requirements for the safe. The correct answer is D. Conduct a detailed, documented risk assessment considering household demographics, access points, and implement enhanced security measures beyond the minimum legal requirements for the safe. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the licensee to proactively identify and mitigate potential risks associated with their firearm ownership, rather than waiting for an incident to occur. The responsibility lies with the licensee to demonstrate due diligence in ensuring the safe storage and responsible use of their Category H firearm, which carries inherent risks. Failure to do so can have serious legal and safety consequences. Correct approach analysis. The best professional practice involves a comprehensive and documented risk assessment that considers all potential scenarios for misuse or accidental discharge. This includes evaluating the security of the storage location, the presence of unauthorized individuals, especially children, and the licensee's own mental and physical state. The assessment should lead to the implementation of specific, practical control measures tailored to the identified risks. For a Category H firearm in the Australian Capital Territory, this aligns with the general duty of care under the Firearms Act 1996 Act and associated regulations, which mandate safe storage and handling to prevent harm. A documented assessment demonstrates a commitment to compliance and responsible ownership. Incorrect approaches analysis. One incorrect approach involves relying solely on the minimum legal storage requirements without considering the specific circumstances of the licensee's household. While the Firearms Act 1996 Act specifies storage standards, these are a baseline. A risk assessment must go beyond this to address unique vulnerabilities, such as the presence of children or individuals with known mental health issues who might access the firearm. This approach fails to demonstrate proactive risk management and could be deemed negligent if an incident occurs. Another incorrect approach is to assume that because the firearm is rarely used, the risk is negligible. This overlooks the potential for opportunistic theft or accidental access, even with infrequent use. The inherent danger of a firearm remains regardless of its usage frequency. A proper risk assessment must account for all potential scenarios, not just those related to active use. A further incorrect approach is to delegate the entire responsibility of safe storage to another household member without verifying their understanding and adherence to safe practices. While shared responsibility can be part of a solution, the ultimate legal responsibility for the firearm's safe custody rests with the licensee. This approach abdicates the licensee's duty of care and fails to ensure that all necessary precautions are being taken. Professional reasoning. Professionals should adopt a proactive and systematic approach to risk management. This involves understanding the specific regulatory obligations, e.g., Firearms Act 1996 Act, identifying potential hazards, assessing the likelihood and severity of harm, and implementing appropriate control measures. Regular review and documentation of these assessments are crucial. When faced with a situation requiring risk assessment, professionals should ask, what are the specific legal requirements? What are the potential harms? Who could be harmed? How likely is it to happen? What can I do to prevent it or reduce the harm? Question 3. Process analysis reveals that an applicant for a Category H firearm license in the Australian Capital Territory must demonstrate a comprehensive understanding of risk assessment. Which of the following approaches best satisfies the regulatory requirements for demonstrating fitness and propriety concerning firearm ownership and safe storage? Option A. Submitting a general statement confirming the applicant's intention to store firearms securely in accordance with legal requirements, without detailing specific risks or mitigation strategies. Option B. Focusing the risk assessment solely on the physical security of the firearm, such as the type of safe used, and neglecting to consider the broader environmental and social factors that could contribute to unauthorized access. Option C. Relying on the applicant's absence of a criminal record as sufficient evidence that no further risk assessment is necessary, assuming that past behavior is the sole determinant of future safety. Option D. Developing a detailed written risk assessment that identifies potential hazards related to firearm ownership and storage, evaluates the likelihood and consequences of these hazards, and outlines specific, proportionate control measures to mitigate identified risks, considering the applicant's specific circumstances and living environment. The correct answer is D. Developing a detailed written risk assessment that identifies potential hazards related to firearm ownership and storage, evaluates the likelihood and consequences of these hazards, and outlines specific, proportionate control measures to mitigate identified risks, considering the applicant's specific circumstances and living environment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to demonstrate a thorough understanding of risk assessment principles as they apply to firearm ownership and safe storage within the Australian Capital Territory Act. The challenge lies in translating theoretical knowledge into practical, actionable steps that satisfy the regulatory requirements of the ACT Firearms Act 1996 and associated regulations, specifically concerning the prevention of unauthorized access and misuse. A superficial understanding could lead to inadequate safety measures, posing a significant risk to public safety and personal security, and potentially resulting in license refusal. Correct approach analysis. The best approach involves a comprehensive and documented risk assessment that identifies potential hazards associated with firearm ownership and storage, evaluates the likelihood and severity of those hazards occurring, and details specific, proportionate control measures to mitigate those risks. This includes considering factors such as the type of firearms, the applicant's living situation, the presence of children or individuals with a history of violence or substance abuse, and the security of the storage location. The justification for this approach is rooted in the ACT Firearms Act 1996, which mandates that license applicants demonstrate they are a fit and proper person to possess a firearm. This inherently requires a proactive and diligent approach to safety and security, as evidenced by the need for a robust risk assessment to satisfy the licensing authority that the applicant can be trusted with firearm ownership. The regulations expect a demonstrable commitment to minimizing risk, which a detailed, documented assessment provides. Incorrect approaches analysis. One incorrect approach involves providing a generic statement of intent to store firearms securely without detailing specific measures or acknowledging potential risks. This fails to meet the ACT Firearms Act's requirement for demonstrating a fit and proper person status, as it lacks the concrete evidence of risk mitigation that a detailed assessment provides. It is ethically and regulatorily insufficient because it does not prove the applicant has considered and addressed potential dangers. Another incorrect approach is to focus solely on the physical security of the firearm itself, e.g., a safe, without considering the broader context of the storage environment and the potential for unauthorized access by individuals. This overlooks critical aspects of risk assessment, such as the psychological state of individuals in the household or the proximity of the storage to unsupervised areas. This approach is flawed because it does not comprehensively address the multifaceted nature of firearm safety as envisioned by the ACT's regulatory framework, which aims to prevent not just theft, but also accidental discharge or intentional misuse. A further incorrect approach is to rely on the assumption that, because the applicant has no prior criminal record, no further risk assessment is necessary. While a clean record is a factor in determining fitness, it does not absolve an applicant of the responsibility to proactively identify and mitigate risks associated with firearm ownership. The ACT regulations require a forward-looking assessment of potential risks, not just a review of past behavior. This approach is deficient as it fails to acknowledge that risks can arise from various factors beyond a criminal history. Professional reasoning. Professionals should adopt a systematic risk management framework. This involves 1. Hazard identification. What could go wrong? E.g., theft, unauthorized access, accidental discharge. 2. Risk analysis. How likely is it to happen and what would be the consequences? 3. Risk evaluation. Is the risk acceptable? 4. Risk treatment. What measures can be put in place to reduce the risk to an acceptable level? 5. Monitoring and review. Are the measures effective and still appropriate? For firearm license applications in the ACT, this translates to a detailed written risk assessment that is submitted as part of the application, demonstrating a thorough understanding of responsibilities and a commitment to public safety. Question 4. The evaluation methodology shows that an applicant for a Category H firearm license in the Australian Capital Territory has provided a detailed written application outlining their genuine reason for wanting to possess a firearm for competitive target shooting, and has included references from 2 individuals who attest to their good character. Considering the paramount importance of public safety and the requirements of the ACT's Firearms Act 1996, which of the following approaches best demonstrates a responsible and compliant risk assessment process? Option A. Expedite the license approval process by relying on the provided references and the stated genuine reason, prioritizing efficiency to reduce the application backlog. Option B. Conduct a thorough review of all submitted documentation, including the applicant's stated genuine reason and references, and schedule a detailed interview with the applicant to probe any potential ambiguities and assess their demeanor and understanding of safe firearm handling. Option C. Accept the applicant's written submission and references at face value, assuming that the provided information is accurate and sufficient for license approval given the stated recreational purpose. Option D. Focus primarily on verifying the applicant's membership in a recognized shooting club and their participation in competitive events, as this is the primary indicator of a genuine reason for a Category H license. The correct answer is B. Conduct a thorough review of all submitted documentation, including the applicant's stated genuine reason and references, and schedule a detailed interview with the applicant to probe any potential ambiguities and assess their demeanor and understanding of safe firearm handling. Explanation. The evaluation methodology shows that assessing the suitability of an applicant for a Category H firearm license in the Australian Capital Territory Act requires a nuanced understanding of risk. This scenario is professionally challenging because it involves balancing the applicant's stated intentions and past behavior against the paramount public safety imperative inherent in firearm licensing. A superficial assessment could lead to a license being granted to an individual who poses an unacceptable risk, while an overly cautious approach might unfairly deny a license to a responsible citizen. The ACT's Firearms Act 1996 and associated regulations mandate a thorough risk assessment that considers not only the applicant's immediate circumstances, but also their history and potential for misuse. The best approach involves a comprehensive review of all provided documentation, including references, and a direct, probing interview to clarify any ambiguities or concerns. This method allows for a holistic evaluation of the applicant's character, genuine reason for possessing a firearm, and overall suitability, directly addressing the requirements of the Firearms Act 1996 Act concerning the assessment of an applicant's fitness and propriety. It prioritizes gathering sufficient information to make an informed decision, aligning with the ethical obligation to protect the community. An approach that relies solely on the applicant's written submission without further verification or interview is professionally unacceptable. This fails to adequately assess the applicant's genuine reason or their potential risk, as written statements can be misleading or incomplete. It neglects the regulatory requirement for a thorough assessment of suitability. Similarly, an approach that focuses exclusively on the applicant's stated recreational shooting activities, while important, is insufficient if it overlooks other risk factors such as past behavioral issues or the nature of their references. This narrow focus may not capture the full spectrum of potential risks. Finally, an approach that prioritizes expediting the application process over thoroughness is ethically and regulatorily unsound. The speed of processing should never compromise the integrity of the risk assessment and the safety of the public. Professionals should employ a structured decision-making process that begins with understanding the legislative framework, Firearms Act 1996 Act, and relevant regulations. This involves identifying all mandatory assessment criteria. Next, they should systematically gather and scrutinize all available information, seeking clarification where necessary. The process should involve a risk-based evaluation, considering both the applicant's stated purpose and any potential red flags. Finally, a decision should be made based on the totality of the evidence, with a clear justification that aligns with regulatory requirements and public safety objectives. Question 5. What factors are most critical for an Australian Capital Territory Category H firearm license applicant to demonstrate during the risk assessment process to ensure they are a fit and proper person? Option A. A comprehensive examination of the applicant's personal circumstances, including mental health, domestic violence history, substance abuse, and proposed secure storage arrangements, alongside their stated genuine reason for possession. Option B. The applicant's stated genuine reason for possessing the firearm, such as participation in a recognized shooting club. Option C. The applicant's willingness to complete the application form quickly and efficiently. Option D. The applicant's self-reported adherence to safe firearm handling and storage practices without independent verification. The correct answer is A. A comprehensive examination of the applicant's personal circumstances, including mental health, domestic violence history, substance abuse, and proposed secure storage arrangements, alongside their stated genuine reason for possession. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to demonstrate not only an understanding of firearm safety, but also a genuine commitment to responsible ownership and the prevention of misuse. The risk assessment process for a Category H firearm license in the Australian Capital Territory Act is designed to identify potential risks to the applicant, the public, and the applicant's household. A superficial or incomplete assessment can lead to a license being granted to an individual who may pose an unacceptable risk, with potentially severe consequences. Careful judgment is required to balance the applicant's right to apply for a license with the community's safety. Correct approach analysis. The best professional practice involves a comprehensive risk assessment that thoroughly examines the applicant's personal circumstances, including their mental health history, any history of domestic violence or substance abuse, their proposed storage arrangements, and their stated genuine reason for possessing the firearm. This approach aligns with the principles of the Firearms Act 1996 Act and its associated regulation, which mandate a rigorous assessment of an applicant's suitability. Specifically, the Act requires the registrar to be satisfied that the applicant is a fit and proper person to possess a firearm, which necessitates a deep dive into these personal factors to identify any potential risks. Ethical considerations also demand a proactive approach to public safety, ensuring that licenses are only granted to those who can demonstrate a clear and present need, and a commitment to safe handling and storage. Incorrect approaches analysis. One incorrect approach involves focusing solely on the applicant's stated genuine reason for possessing the firearm, such as sport shooting, without adequately investigating other risk factors. This fails to meet the legislative requirement to assess the applicant as a fit and proper person by ignoring potential underlying issues that could compromise safety, such as untreated mental health conditions or a history of impulsive behavior. Another incorrect approach is to rely entirely on the applicant's self-declaration of safety and storage practices without independent verification or further inquiry. This approach is deficient because it does not adequately address the legislative requirement for secure storage, and the registrars need to be satisfied that these arrangements are robust and compliant with the Firearms Act 1996 Act. It assumes honesty and competence without due diligence. A further incorrect approach is to prioritize the applicant's convenience and minimize the time spent on the assessment process, leading to a cursory review of documentation and a brief interview. This is ethically and regulatorily unsound, as it compromises the thoroughness required by the ACT firearms licensing framework, potentially overlooking critical risk indicators and failing to uphold the duty of care owed to the public. Professional reasoning. Professionals involved in firearms licensing in the ACT should adopt a structured risk assessment framework. This framework should begin with a thorough review of all submitted documentation, followed by a detailed interview designed to probe potential risk factors. It should include verification of information where possible and a clear process for escalating concerns or requesting further information. The decision-making process must be guided by the legislative requirements of the Firearms Act 1996 Act and the overarching ethical imperative to protect public safety. Professionals should be trained to identify red flags and understand the implications of various personal circumstances on firearm safety. Question 6. Compliance review shows that an Australian Capital Territory Category H firearm license holder has stored their firearms in a compliance safe as per the minimum legislative requirements. However, the licensee has recently experienced significant personal stress and has young children visiting their home regularly. What is the most appropriate risk assessment approach for this licensee to adopt moving forward? Option A. Conduct a comprehensive, documented risk assessment that considers the specific environmental and personal factors, including the presence of children and the licensee's recent stress levels, and implement additional control measures as identified. Option B. Assume that the risk is minimal because the firearms are stored in a safe and the licensee has held the license for many years without issue. Option C. Ask a family member who is also a firearm owner to review the storage arrangements and confirm compliance without the licensee's direct involvement in the assessment process. Option D. Continue to rely on the existing compliant storage, as the firearms are legally stored and no incidents have occurred previously. The correct answer is A. Conduct a comprehensive, documented risk assessment that considers the specific environmental and personal factors, including the presence of children and the licensee's recent stress levels, and implement additional control measures as identified. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the licensee to proactively identify and mitigate potential risks associated with their firearm ownership, rather than waiting for an incident to occur. The Australian Capital Territory Act, Firearm Act 1996, and associated regulations place a significant onus on licensees to maintain safe storage and responsible handling practices. Failure to adequately assess and manage these risks can lead to breaches of license conditions, potential harm to individuals, and legal repercussions. Careful judgment is required to balance the right to own a firearm with the paramount responsibility for public safety. Correct approach analysis. The best professional practice involves a comprehensive, documented risk assessment that considers all potential scenarios for misuse, theft, or accidental discharge. This includes evaluating the security of the storage location, the presence of unauthorized individuals, especially children, the physical and mental well-being of the licensee and any other persons with access, and the specific types of firearms and ammunition possessed. This approach aligns with the spirit and letter of the ACT Firearm Act 1996, which mandates responsible ownership and the prevention of harm. A documented assessment provides evidence of due diligence and allows for the implementation of targeted control measures, such as enhanced security, regular inspections, and clear protocols for access. Incorrect approaches analysis. One incorrect approach involves relying solely on the basic storage requirements mandated by law without considering specific environmental or personal factors. This fails to address unique vulnerabilities, such as a history of mental health issues, proximity to schools, or inadequate security measures beyond a standard safe. It represents a minimum compliance mindset rather than a proactive risk management strategy. Another incorrect approach is to assume that because a firearm has been owned for a long time without incident, no further risk assessment is necessary. This overlooks the dynamic nature of risk, which can change due to evolving personal circumstances, changes in the household, or increased accessibility of the firearm. It is a passive approach that neglects the ongoing duty of care. A third incorrect approach is to delegate the entire responsibility for risk assessment to a family member or associate without personal oversight or understanding of the assessment's findings. While seeking advice can be beneficial, the ultimate responsibility for safe and responsible firearm ownership rests with the licensee. This abdication of responsibility can lead to overlooked risks and a failure to implement appropriate safety measures. Professional reasoning. Professionals should adopt a proactive and systematic approach to risk management. This involves regularly reviewing license conditions, understanding the specific legislative requirements of the ACT, and conducting a thorough, documented risk assessment tailored to their individual circumstances. The decision-making process should prioritize the safety of the community and oneself, ensuring that all reasonable steps are taken to prevent any potential misuse or harm. This includes seeking expert advice when necessary and maintaining a continuous cycle of assessment, implementation of controls, and review. Question 7. The evaluation methodology shows that when assessing an Australian Capital Territory Category H firearm license application, which approach best mitigates potential risks to public safety while adhering to the Firearms Act 1996. Option A. Automatically reject the application if the applicant has any history of mental health conditions, regardless of their current management or the nature of the condition. Option B. Prioritize the applicant's stated reasons for seeking the license, such as sport shooting or collection, above all other considerations in the assessment process. Option C. Rely exclusively on a national police check to confirm the absence of criminal convictions, disregarding any self-declared health conditions or the content of reference letters. Option D. Conduct a comprehensive review of all submitted documentation, including reference checks and any declared mental health history, followed by a structured interview to assess the applicant's understanding of firearm safety and responsible ownership. The correct answer is D. Conduct a comprehensive review of all submitted documentation, including reference checks and any declared mental health history, followed by a structured interview to assess the applicant's understanding of firearm safety and responsible ownership. Explanation. The evaluation methodology shows that assessing the suitability of a Category H firearm license applicant in the Australian Capital Territory Act requires a comprehensive risk assessment that goes beyond simply checking for a clean criminal record. This scenario is professionally challenging because it involves balancing the applicant's right to apply for a license with the paramount public safety obligations of the licensing authority. The decision requires careful judgment to identify potential risks that might not be immediately apparent through standard checks. The best approach involves a thorough review of all provided documentation, including references and any declared mental health history, coupled with an interview to gauge the applicant's understanding of firearm safety and responsible ownership. This method is correct because it aligns with the ACT's Firearms Act 1996 and associated regulations, which mandate a holistic assessment of an applicant's suitability, including their character, mental state, and any factors that might indicate a risk of misuse. The interview allows for direct observation and clarification of any ambiguities, ensuring a well-informed decision that prioritizes public safety while adhering to due process. An approach that relies solely on a police check and ignores the applicant's self-declared history of anxiety and the content of their reference letters is incorrect. This fails to meet the legislative requirement for a comprehensive risk assessment and could lead to a license being granted to an individual who may pose a risk, thereby violating the duty of care to the public. Another incorrect approach would be to automatically deny the license based on the self-declared anxiety without further investigation. Mental health is a critical factor. The legislation requires an assessment of the risk posed by the condition, not an automatic disqualification. This approach is discriminatory and does not allow for individualized assessment, potentially denying a license to someone who manages their condition effectively and poses no undue risk. Furthermore, an approach that prioritizes the applicant's desire for the license over the licensing authority's public safety mandate is fundamentally flawed. The primary objective of firearm licensing is to ensure that only responsible individuals possess firearms, and this must always take precedence over an applicant's personal aspirations. Professionals should employ a decision-making framework that begins with understanding the specific legislative requirements of the ACT Firearms Act 1996. This framework should include a systematic review of all submitted information, identification of potential risk factors, and a structured interview process designed to probe these factors. The decision should be based on a balanced consideration of all evidence, with a clear emphasis on public safety as the overriding principle. Question 8. The control framework reveals that a Category H firearm license holder in the Australian Capital Territory has recently experienced a severe personal crisis that has significantly impacted their mental well-being. What is the most appropriate course of action for this license holder to ensure compliance with ACT firearms legislation and uphold public safety? Option A. Only report the personal crisis if directly asked about their mental health by law enforcement or the ACT Firearms Registry. Option B. Wait to see if their mental well-being improves before considering any notification to the ACT Firearms Registry. Option C. Inform close friends and family about the crisis, but refrain from reporting it to the ACT Firearms Registry unless a specific incident occurs. Option D. Immediately report the personal crisis and its impact on their mental well-being to the ACT Firearms Registry. The correct answer is D. Immediately report the personal crisis and its impact on their mental well-being to the ACT Firearms Registry. Explanation. The control framework reveals a scenario where a Category H firearm license holder in the Australian Capital Territory Act has experienced a significant personal crisis. This situation is professionally challenging because it directly impacts the license holder's suitability to possess firearms, requiring a delicate balance between public safety, individual rights, and adherence to strict legislative requirements. The ACT's firearms legislation, specifically the Firearms Act 1996 Act and associated regulations, mandates that license holders must remain fit and proper persons to possess firearms. This includes having regard to their mental and physical health and any history of violence or instability. The best professional practice in this scenario involves the license holder proactively and immediately reporting the significant personal crisis to the ACT Firearms Registry. This approach aligns with the core principles of responsible firearm ownership and the legislative intent of the Firearms Act 1996 Act. Section 31 of the Act requires a license holder to notify the registrar of any change in circumstances that may affect their eligibility for a license, including significant changes in mental health. Prompt notification allows the registrar to assess the current risk and take appropriate action, which could range from imposing conditions on the license to suspension or cancellation, thereby upholding public safety while allowing for a fair process. This proactive disclosure demonstrates a commitment to compliance and public safety. An incorrect approach would be to delay reporting the crisis, hoping it resolves itself or that it won't be discovered. This failure to notify the registrar, as required by Section 31 of the Firearms Act 1996 Act, constitutes a breach of the license conditions and demonstrates a disregard for the legislative obligations, creates an unacceptable risk to public safety by allowing a potentially unfit individual to retain access to firearms without proper oversight. Another incorrect approach would be to only report the crisis if directly questioned by authorities or if a specific incident occurs. This reactive stance is insufficient. The legislation places a positive obligation on license holders to inform the registrar of relevant changes in their circumstances. Waiting to be prompted or until a crisis point is reached undermines the preventative nature of the licensing system and the duty of care owed to the community. Finally, an incorrect approach would be to confide in a friend or family member but not formally report the situation to the ACT Firearms Registry. While seeking support is important, it does not fulfill the legal requirement to inform the regulatory authority. The responsibility lies with the license holder to ensure the relevant authorities are aware of any factors that might compromise their suitability to possess firearms, irrespective of personal support networks. Professionals in similar situations should adopt a framework of immediate disclosure and transparency. This involves understanding the specific reporting obligations under the Firearms Act 1996 Act, assessing the severity of the personal circumstances against the criteria for license eligibility, and acting promptly to inform the ACT Firearms Registry. Ethical considerations of public safety and legal compliance should always take precedence. Question 9. The control framework reveals an applicant for Category H firearm license in the Australian Capital Territory has a history of documented domestic disputes. Which of the following approaches best demonstrates adherence to the regulatory requirements and professional best practice for assessing this applicant's suitability? Option A. Automatically deny the license application due to the presence of domestic dispute history, as this inherently indicates a risk to public safety. Option B. Rely on informal inquiries and community feedback regarding the applicant's past behavior to determine their suitability for a license. Option C. Conduct a thorough review of all available documentation related to the domestic disputes, including police reports and court records, to assess the applicant's character and propensity for violence against the criteria for license eligibility under the Firearms Act 1996 Act. Option D. Grant the license without further investigation, assuming that past disputes that did not lead to criminal convictions are not relevant to current firearm ownership. Correct answer is C. Conduct a thorough review of all available documentation related to the domestic disputes, including police reports and court records, to assess the applicant's character and propensity for violence against the criteria for license eligibility under the Firearms Act 1996 Act. Explanation. The control framework reveals a scenario where an applicant for a Category H firearm license in the Australian Capital Territory Act has a history of domestic disputes. This situation is professionally challenging because it requires balancing the applicant's right to apply for a license against the paramount public safety considerations mandated by ACT firearm legislation. The decision-maker must meticulously assess the risk posed by the applicant's past behavior without resorting to prejudice, adhering strictly to the legal criteria for license eligibility. The best professional practice involves a thorough, objective assessment of the applicant's suitability, directly referencing the criteria outlined in the Firearms Act 1996 Act and its associated regulations. This approach necessitates obtaining and reviewing all relevant documentation, including police reports, court records, and any evidence of rehabilitation or ongoing risk. The decision-maker must consider whether the past domestic disputes demonstrate a propensity for violence or a lack of judgment that would render the applicant a danger to themselves or others if granted a firearm license, as per the Act's requirements concerning the applicant's character and suitability. This aligns with the legislative intent to prevent firearms from falling into the hands of individuals who pose a risk. An incorrect approach would be to automatically deny the license based solely on the mention of domestic disputes, without a comprehensive review of the circumstances. This fails to adhere to the principle of due process and the statutory requirement for a factual assessment of risk. It also risks being discriminatory and not based on the specific grounds for refusal outlined in the legislation, such as a demonstrated propensity for violence. Another unacceptable approach is to grant the license without any further investigation, assuming that past disputes are irrelevant if they did not result in a criminal conviction. This overlooks the broader mandate of the legislation to ensure public safety and the responsibility of the licensing authority to assess an applicant's overall suitability, which extends beyond mere criminal convictions to include behavior that indicates a potential risk. A further flawed approach would be to rely on anecdotal information or hearsay from individuals without verifying its accuracy or relevance to the applicant's current suitability. This introduces an element of unreliability and bias into the decision-making process, contravening the need for evidence-based assessment as required by administrative law principles and the specific provisions of the Firearms Act 1996 Act. Professionals should employ a structured decision-making process that begins with understanding the specific legal requirements of the ACT Firearms Act 1996. This involves identifying all relevant criteria for license eligibility and refusal. The next step is to gather all pertinent evidence, ensuring it is factual and directly addresses the legal criteria. This evidence must then be objectively evaluated against the legislative standards, considering any mitigating or aggravating factors. Finally, a decision must be made and clearly documented, demonstrating how the evidence supports the conclusion reached in accordance with the law. Question 10. The control framework reveals that a Category H firearm license holder in the Australian Capital Territory is preparing to transport their firearms and ammunition. They possess 2 handguns weighing 2 kg and 5 kg respectively along with their cases. They also have 3 boxes of ammunition, each weighing 8 kg, and a separate bag of cleaning supplies weighing 3 kg. If the maximum permissible combined weight for transport under ACT regulations is 0 kg and the license holder must account for the weight of firearms, their cases, and ammunition, what is the total weight they are transporting? Option A, 0 kg. Option B, 4 kg. Option C, 7 kg. Option D, 3 kg. Correct answer is A, 0 kg. Explanation: scenario analysis. This scenario presents a professional challenge for a Category H firearm license holder in the Australian Capital Territory Act by requiring them to accurately calculate the total weight of firearms and ammunition for transport. The challenge lies in ensuring compliance with specific legislative weight limits, which, if exceeded, can lead to license suspension or cancellation and potential legal penalties. Accurate calculation is paramount to avoid contravening the Firearms Act 1996 Act and its associated regulations, which dictate safe storage and transport requirements. The license holder must demonstrate a thorough understanding of the weight specifications of their firearms and ammunition and the ability to perform precise calculations. Correct approach analysis. The best professional practice involves meticulously weighing each individual firearm and each distinct category of ammunition, e.g., pistol cartridges, rifle cartridges, separately. This detailed approach ensures that the total weight is accurately determined by summing these individual weights. Specifically for firearms, the license holder must account for the firearm itself, any attached accessories that are integral to its operation or transport, e.g., scopes, suppressors if legally permitted and attached, and the weight of the firearm's case or container. For ammunition, each box or package of ammunition must be weighed. The sum of these individual weights provides the definitive total weight for transport. This method directly adheres to the spirit and letter of the Firearms Act 1996 Act and the Australian Capital Territory, Firearms, Regulation 2019, which mandate that license holders must ensure their firearms and ammunition are transported in a manner that complies with safety and weight provisions. This precise calculation method leaves no room for ambiguity and directly addresses the legislative requirement to not exceed specified transport weight limits. Incorrect approaches analysis. One incorrect approach is to estimate the weight of the firearms and ammunition based on general knowledge or by approximating the weight of similar items. This method is professionally unacceptable because it relies on subjective judgment rather than objective measurement, increasing the risk of exceeding legal weight limits. The Firearms Act 1996 Act requires demonstrable compliance, and estimations do not provide this. Another incorrect approach is to only weigh the firearms and disregard the weight of the ammunition. This is a significant regulatory failure, as the legislation typically considers the combined weight of firearms and ammunition for transport purposes. Failing to include ammunition weight will lead to an inaccurate total, potentially resulting in non-compliance with weight restrictions. A further incorrect approach is to weigh the firearms and ammunition together in a single, large container without accounting for individual item weights. While this might provide a total, it lacks the detail required to identify if specific components are contributing disproportionately to the weight, or if a particular firearm or ammunition type is close to its individual limit, if such limits exist within the broader transport weight regulations. This method is less robust in demonstrating precise adherence to all potential weight-related provisions. Professional reasoning. Professionals in the ACT must adopt a systematic and precise approach to all aspects of firearm ownership, including transport. The decision-making process should always prioritize legislative compliance and safety. This involves 1. Understanding the specific requirements of the Firearms Act 1996 Act and the Australian Capital Territory, Firearms, Regulation 2019 regarding firearm and ammunition transport, including any stated weight limits. 2. Employing accurate measurement tools such as a calibrated scale to determine the weight of each component. 3. Performing calculations meticulously, ensuring all relevant items are included. 4. Documenting the calculations and measurements to provide evidence of compliance if required. 5. In cases of doubt or complexity, seeking clarification from the relevant ACT authorities. Question 11. Benchmark analysis indicates that a Category H firearm license holder in the Australian Capital Territory is preparing to transport their firearm to a licensed shooting range. Considering the regulatory framework governing firearm possession and transport in the ACT, which of the following actions best demonstrates compliance with the law and professional responsibility? Option A. The firearm is unloaded and placed in its original case on the passenger seat of the vehicle, while ammunition is stored in the glove compartment. Option B. The firearm is unloaded, placed in a locked gun bag, and transported directly to and from the licensed shooting range, with ammunition stored separately in a locked container. Option C. The firearm is unloaded and placed in the boot of the car in its original case, with ammunition stored separately in a locked container in the glove compartment. Option D. The firearm is unloaded and placed in a locked gun bag, but the license holder stops at a friend's house for a brief period on the way to the shooting range. The correct answer is B. The firearm is unloaded, placed in a locked gun bag, and transported directly to and from the licensed shooting range, with ammunition stored separately in a locked container. Explanation. Scenario analysis. This scenario presents a professional challenge for a Category H firearm license holder in the Australian Capital Territory, Act, due to the strict regulations surrounding the storage and transportation of firearms. The core difficulty lies in balancing the legal requirements for secure storage with the practical need to transport the firearm for a legitimate purpose, such as attending a licensed shooting range. Failure to comply can result in severe penalties, including license suspension or cancellation, and potential criminal charges. The license holder must demonstrate a thorough understanding of the ACT's Firearms Act 1996 and associated regulations. Correct approach analysis. The best professional practice involves ensuring the firearm is unloaded, secured in a locked container that is separate from its ammunition, and transported directly to and from the licensed premises. This approach aligns with the ACT Firearms Act 1996, specifically sections pertaining to the safe storage and transport of firearms. The law mandates that firearms must be rendered inoperable and stored securely when not under direct supervision, and transport must be conducted in a manner that minimizes risk. Transporting the firearm directly to and from the range without any detours or unauthorized stops is crucial for demonstrating responsible ownership and adherence to the spirit of the law, which prioritizes public safety. Incorrect approaches analysis. Transporting the firearm in the boot of the car, unlocked, while the ammunition is in the glove compartment, fails to meet the requirement for a locked container and the separation of firearm and ammunition. This creates an immediate risk and contravenes the ACT's stringent storage and transport provisions, which are designed to prevent unauthorized access and use. Leaving the firearm unloaded, but in its original case on the passenger seat of the vehicle, even for a short period while running an errand, is a significant breach of security. This exposes the firearm to potential theft and unauthorized access, directly violating the license holder's duty of care and the legal obligations under the ACT Firearms Act 1996. Transporting the firearm in a locked container, but stopping at a friend's house on the way to the range, introduces an unauthorized stop and potential for the firearm to be accessible or observed by unauthorized individuals. This deviates from the principle of direct transport to and from a licensed activity and increases the risk profile, which is contrary to the regulatory intent of safe and secure firearm handling. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes understanding and strict adherence to the specific legislative requirements of their jurisdiction. This involves 1. Identifying the specific purpose of firearm possession or transport. 2. Consulting the relevant legislation, in this case, the ACT Firearms Act 1996 and associated regulations, for explicit requirements regarding storage and transport. 3. Planning the entire process, including the route and any necessary stops, to ensure compliance at all stages. 4. Prioritizing security and safety above convenience. 5. Seeking clarification from the relevant authorities if any aspect of the regulations is unclear. Question 12. The control framework reveals that a Category H firearm license holder in the Australian Capital Territory is considering making a modification to their firearm. What is the most appropriate course of action to ensure compliance with ACT firearms legislation? Option A. Proceed with the modification, assuming that minor changes are generally permissible for legally owned firearms. Option B. Seek informal advice from a gunsmith or other firearm owners about the legality of the modification. Option C. Contact the ACT Firearms Registry to inquire about the specific requirements for the proposed modification and obtain written approval before proceeding. Option D. Undertake the modification, as the firearm is legally owned and therefore any alterations are acceptable. Correct answer is C. Contact the ACT Firearms Registry to inquire about the specific requirements for the proposed modification and obtain written approval before proceeding. Explanation. The control framework reveals a scenario where a Category H firearm license holder in the Australian Capital Territory Act is seeking to modify their firearm. This situation is professionally challenging because it requires a thorough understanding of the ACT's specific firearms legislation, particularly concerning modifications and the licensing requirements for such actions. Failure to adhere to these regulations can lead to serious legal consequences, including license suspension or cancellation, and potential criminal charges. The core of the challenge lies in balancing the license holder's desire for modification with the paramount importance of public safety and compliance with the Firearms Act 1996 Act and its associated regulations. The best professional practice involves proactively seeking and obtaining the necessary approvals before undertaking any modifications. This approach prioritizes compliance and safety. Specifically, The license holder should contact the ACT Firearms Registry to understand the specific requirements for modifying a Category H firearm. This would typically involve submitting an application for approval of the modification, detailing the nature of the proposed changes and the reasons for them. The Firearms Registry would then assess the application against the legislative requirements, considering factors such as the type of firearm, the proposed modification, and whether it would render the firearm unsafe or contrary to public interest. Obtaining written approval from the ACT Firearms Registry prior to any modification is a mandatory step under ACT law for certain types of modifications. This ensures that any changes are permissible and do not contravene the conditions of the license or the Act. An incorrect approach would be to proceed with the modification without prior consultation or approval, assuming that minor changes are permissible. This fails to acknowledge the strict regulatory oversight governing firearms in the ACT. The Firearms Act 1996 Act places a responsibility on license holders to ensure their firearms are maintained in a safe and compliant condition, and that any alterations are authorized. Proceeding without approval constitutes a breach of these obligations. Another incorrect approach is to rely on informal advice from a gunsmith or other license holders regarding the legality of the modification. While such advice might be well-intentioned, it does not substitute for official approval from the ACT Firearms Registry. The registry is the sole authority for determining compliance with ACT firearms laws. Relying on informal advice risks misinterpreting the law or overlooking specific requirements, leading to a breach. A further incorrect approach would be to assume that because the firearm is legally owned, any modification is automatically permitted. This overlooks the fact that firearm ownership is conditional upon adherence to a range of regulations, including those pertaining to the firearm's configuration and safety. Modifications can alter a firearm's classification, safety features, or suitability for its intended purpose, all of which are subject to regulatory scrutiny. The professional decision-making process for similar situations should begin with a clear understanding of the governing legislation. In this case, it is the Firearms Act 1996 Act and associated regulations. Professionals must always err on the side of caution and assume that any alteration to a licensed firearm requires scrutiny and potentially approval. The primary step should always be to consult the relevant regulatory authority, the ACT Firearms Registry, to ascertain the specific requirements and obtain any necessary authorizations before proceeding. This proactive approach minimizes risk and ensures compliance. Question 13. Quality control measures reveal that a Category H firearm license holder in the Australian Capital Territory is planning to attend a licensed shooting range. They intend to transport their unloaded firearm in its original box, which is not locked, and stop at a friend's house to drop off some items before proceeding to the range. Which of the following actions best demonstrates compliance with the Australian Capital Territory's firearms regulations for transport? Option A. Transport the firearm loaded but in a locked case and stop at a local shop to pick up supplies before heading to the range. Option B. Carry the firearm unloaded in the boot of the car with the ammunition stored separately in the glove compartment, and then stop for groceries after the range session. Option C. Transport the firearm unloaded in its original box without a lock, and stop at a friend's house on the way to the range. Option D. Transport the unloaded firearm in a locked firearm safe or case, traveling directly to and from the licensed shooting range without any unnecessary stops. The correct answer is D. Transport the unloaded firearm in a locked firearm safe or case, traveling directly to and from the licensed shooting range without any unnecessary stops. Explanation. Scenario analysis. This scenario presents a professional challenge for a Category H firearm license holder in the Australian Capital Territory Act, due to the strict regulations surrounding the storage and transportation of firearms. The core difficulty lies in balancing the legal requirements for secure storage with the practicalities of attending a licensed shooting range. Misinterpreting or neglecting these requirements can lead to serious legal consequences, including license suspension or cancellation, and potential criminal charges. The license holder must demonstrate a thorough understanding of the Firearms Act 1996 Act and its associated regulations concerning safe storage and transport. Correct approach analysis. The best professional practice involves ensuring the firearm is unloaded, secured in a locked firearm safe or case, and transported directly to and from the licensed shooting range without any unnecessary stops or deviations. This approach directly adheres to the requirements of the Firearms Act 1996 Act, specifically sections pertaining to the safe storage and transport of firearms. The Act mandates that firearms must be stored securely and transported in a manner that prevents unauthorized access or use. Transporting an unloaded firearm in a locked container directly to the range and back is the most compliant method, minimizing risk and fulfilling legal obligations. Incorrect approaches analysis. Transporting the firearm unloaded but in its original box without a lock and stopping at a friend's house on the way to the range is a regulatory failure. While the firearm is unloaded, the lack of a locked container does not meet the secure storage requirements during transport. Furthermore, stopping at friend's residence introduces an unauthorized location and potential for unauthorized access, violating the principle of direct transport to a licensed premise. Carrying the firearm unloaded in the boot of the car with the ammunition stored separately in the glove compartment, and then stopping for groceries after the range session, is also a regulatory failure. Although ammunition is stored separately, the firearm itself is not secured in a locked container, leaving it vulnerable to theft or unauthorized access. Stopping for groceries after the range session constitutes an unnecessary deviation from direct transport, potentially exposing the firearm to public view or risk of theft. Transporting the firearm loaded but in a locked case and stopping at a local shop to pick up supplies before heading to the range is a significant regulatory failure. The Firearms Act 1996 Act strictly prohibits the transport of loaded firearms except under specific authorized circumstances, which do not apply to general transport to a shooting range. Additionally, stopping at a shop introduces an unauthorized stop and potential for unauthorized access. Professional reasoning. Professionals in possession of firearms must adopt a proactive and meticulous approach to compliance. This involves thoroughly understanding the relevant legislation, such as the Firearms Act 1996 Act, and consulting official resources or authorities if any doubt exists regarding storage or transport protocols. The decision-making process should prioritize safety and legal adherence above all else. When faced with practical considerations, such as attending a range, the professional must always default to the most secure and legally compliant method, even if it requires minor adjustments to personal convenience. This involves a risk assessment where the potential legal and safety consequences of non-compliance far outweigh any perceived benefit of a less secure or direct transport method. Question 14. The audit findings indicate a report of a Category H firearm being stored in a manner that may not fully comply with the Australian Capital Territory's Firearms Act 1996 storage requirements. What is the most appropriate immediate course of action for the licensing authority? Option A. Initiate a formal investigation to gather all relevant facts, including details of the alleged noncompliance, the licensee's explanation, and any potential risks before determining the appropriate regulatory response. Option B. Advise the licensee via email that the storage requirements must be met immediately and close the matter without further investigation. Option C. File the audit finding as a minor administrative note and take no immediate action, assuming the licensee will self-rectify. Option D. Immediately suspend the licensee's Category H firearm license, pending a full review, citing the potential breach of storage regulations. The correct answer is A. Initiate a formal investigation to gather all relevant facts, including details of the alleged noncompliance, the licensee's explanation, and any potential risks, before determining the appropriate regulatory response. Explanation. The audit findings indicate a potential lapse in the responsible storage of firearms, which is a critical area for maintaining public safety and compliance with the Australian Capital Territory's Firearms Act 1996 and associated regulations. This scenario is professionally challenging because it requires immediate and decisive action to mitigate risk, uphold legal obligations, and ensure the integrity of the licensing system, all while balancing the rights of the licensee. The core of the challenge lies in accurately assessing the severity of the breach and implementing the most appropriate regulatory response without prejudicing the licensee unnecessarily or compromising public safety. The best professional practice involves a thorough, objective, and documented investigation into the reported storage deficiency. This approach prioritizes gathering all relevant facts, including the nature of the deficiency, the licensee's explanation, and any mitigating circumstances. It adheres to the principles of procedural fairness and due process mandated by ACT legislation, which requires that decisions affecting a license holder be based on evidence and a proper assessment of risk. This methodical approach ensures that any subsequent action, such as issuing a warning, requiring immediate rectification, or initiating license review, is proportionate to the identified risk and legally sound. The focus is on ensuring compliance and safety, not on punitive measures without due cause. Failing to investigate the reported deficiency thoroughly is professionally unacceptable. This could involve accepting the licensee's word without verification, or making a decision based on incomplete information. Such an approach risks overlooking a genuine safety hazard, potentially leading to a serious incident and exposing the ACT government to liability. It also undermines the regulatory framework by not enforcing its provisions effectively. Another unacceptable approach is to immediately recommend license suspension or cancellation based solely on the report, without allowing the licensee an opportunity to explain or rectify the issue. This is overly punitive, fails to consider the licensee's history or the specific circumstances of the deficiency, and contravenes the principles of natural justice and the legislative intent to manage firearm ownership responsibly rather than simply revoking licenses without due process. Finally, ignoring the report entirely or delaying action indefinitely is a severe dereliction of duty. This approach creates an unacceptable risk to public safety by allowing a potentially unsafe storage situation to persist. It also demonstrates a disregard for the regulatory obligations and the importance of maintaining an effective firearms registry and compliance regime in the Australian Capital Territory. Professionals in this situation should employ a structured decision-making process. 1. Acknowledge and record the report immediately. 2. Initiate a prompt and impartial investigation to gather all pertinent facts. 3. Engage with the licensee to understand the circumstances and their proposed solutions. 4. Assess the level of risk posed by the deficiency. 5. Determine the most appropriate regulatory response based on the investigation findings, legislative requirements, and principles of fairness and proportionality. 6. Document all steps taken and decisions made. Question 15. The performance metrics show a significant increase in the backlog of Category H firearm license applications within the Australian Capital Territory. In response, a proposed strategy is to streamline the assessment process by reducing the number of mandatory verification steps for applicants who have previously held a firearm license. Which of the following approaches best upholds the integrity of the Australian Capital Territory's firearm licensing system and public safety? Option A. Maintain rigorous verification of all statutory requirements for every application, including identity, genuine reason, and suitability checks, regardless of previous license history, to ensure full compliance with the Firearms Act 1996 Act. Option B. Expedite applications from previous license holders by relying heavily on their past records and minimizing current verification steps, thereby reducing the backlog. Option C. Focus verification efforts primarily on new applicants and those with a history of license breaches, while fast-tracking all other renewals, including Category H. Option D. Implement a system where only a random sample of previous license holders' applications undergo full verification, while others are processed based on a declaration of continued eligibility. Correct answer is A. Maintain rigorous verification of all statutory requirements for every application, including identity, genuine reason, and suitability checks, regardless of previous license history, to ensure full compliance with the Firearms Act 1996 Act. Explanation. The performance metrics show a concerning trend in the handling of Category H firearm license applications within the Australian Capital Territory Act. This scenario is professionally challenging because it requires balancing the strict regulatory requirements for firearm licensing with the need for efficient and fair processing. A failure in either aspect can have serious consequences, including compromising public safety or unfairly disadvantaging applicants. Careful judgment is required to ensure compliance with the Firearms Act 1996 Act and its associated regulation, while also upholding principles of good governance and administrative fairness. The best approach involves a thorough review of the application against all statutory requirements, including verification of identity, proof of genuine reason for possessing a firearm, and assessment of the applicant's suitability, which includes checks for any disqualifying factors as outlined in the Firearms Act 1996 Act. This meticulous process ensures that only eligible individuals are granted licenses, thereby upholding public safety and adhering to the legislative framework. It prioritizes compliance with the ACT's specific firearm licensing laws, which mandate a rigorous assessment of each application. An approach that prioritizes speed over thoroughness by expediting applications without fully verifying all required documentation or conducting comprehensive background checks is professionally unacceptable. This failure directly contravenes the spirit and letter of the Firearms Act 1996 Act, which places a strong emphasis on due diligence to prevent firearms from falling into the wrong hands. Such an approach risks issuing licenses to individuals who may pose a risk to themselves or others, thereby failing in the primary duty of care mandated by the legislation. Another unacceptable approach is to rely solely on the applicant's self-declaration for critical aspects like genuine reason or suitability without independent verification. While self-declaration forms part of the process, the Firearms Act 1996 Act implies a duty for the licensing authority to conduct reasonable checks to confirm the veracity of information provided, especially concerning safety and eligibility. Failing to do so represents a dereliction of the licensing authority's responsibilities under the Act. Finally, an approach that applies inconsistent standards to different applicants, perhaps based on subjective factors or perceived urgency, undermines the principle of administrative fairness and can lead to legal challenges. The Firearms Act 1996 Act requires that all applications be assessed against the same objective criteria, ensuring equity and preventing bias. Professionals should adopt a decision-making framework that begins with a clear understanding of the legislative requirements. This involves systematically checking each criterion against the provided evidence, seeking clarification or further information where necessary, and documenting all decisions and the reasons behind them. When faced with performance metrics indicating potential systemic issues, professionals must escalate these concerns to identify and rectify underlying problems in the application processing system, rather than compromising individual application integrity. Question 16. Stakeholder feedback indicates a need to clarify best practices for Category H firearm license holders in the Australian Capital Territory regarding the secure storage of their firearm when not in immediate use. Considering the requirements of the Firearms Act 1996 Act, which of the following approaches best ensures compliance and safety? Option A. Transporting the firearm unloaded but with the ammunition stored in the same locked gun case, secured to a fixed object. Option B. Leaving the firearm unloaded and disassembled in a locked drawer within a residential property. Option C. Storing the firearm loaded in a locked gun safe that is not secured to a fixed object. Option D. Storing the firearm unloaded with the action open and secured separately from its ammunition in a locked container that is itself secured to a fixed object. The correct answer is D. Storing the firearm unloaded with the action open and secured separately from its ammunition in a locked container that is itself secured to a fixed object. Explanation. Scenario analysis. This scenario presents a professional challenge for Category H firearm license holder in the Australian Capital Territory Act due to the strict legislative requirements surrounding the storage and transport of firearms. The core difficulty lies in balancing the need for secure storage with the practicalities of occasional use, while strictly adhering to the Firearms Act 1996 Act and its associated regulations. Failure to comply can result in severe penalties, including license suspension or cancellation, and criminal charges. Correct approach analysis. The best professional practice involves understanding and applying the specific storage requirements outlined in the Firearms Act 1996 Act and the relevant regulations. This means ensuring the firearm is stored unloaded, with the action open, and secured separately from its ammunition in a locked container that is itself secured to a fixed object or is of a substantial construction that prevents unauthorized access. The firearm must also be stored in a manner that prevents it from being readily accessible. This approach is correct because it directly addresses the legislative intent of the ACT firearms laws, which is to minimize the risk of accidental discharge, theft, or misuse of firearms. The separation of firearm and ammunition, coupled with secure locking mechanisms and attachment to a fixed object, are explicit requirements designed to achieve this safety objective. Incorrect approach is analysis. Storing the firearm loaded in a locked gun safe that is not secured to a fixed object is an incorrect approach. While the gun safe provides a level of security, the ACT legislation requires that the firearm be secured to a fixed object to prevent its removal. Storing it loaded also directly contravenes the requirement for the firearm to be stored unloaded. Transporting the firearm unloaded, but with the ammunition stored in the same locked gun case, even if the case is secured to a fixed object, is also incorrect. The regulations mandate that the firearm and ammunition must be stored separately. This separation is a critical safety measure to prevent immediate use of the firearm. Leaving the firearm unloaded and disassembled in a locked drawer within a residential property, without any further security measures such as a dedicated gun safe or securing it to a fixed object, is an unacceptable approach. This method does not meet the legislative standard for secure storage, as it does not prevent unauthorized access or the potential for the firearm to be readily accessible. Professional reasoning. Professionals in the ACT must adopt a proactive and diligent approach to firearm storage and transport. This involves thoroughly familiarizing themselves with the Firearms Act 1996 Act and its regulations, and treating compliance not as a burden, but as a fundamental ethical and legal responsibility. When in doubt about specific requirements, seeking clarification from the ACT Firearms Registry or a qualified legal professional is paramount. The decision-making process should prioritize safety and legislative compliance above all else, ensuring that all actions taken are demonstrably in accordance with the law. Question 17. Regulatory review indicates that a Category H firearm license holder in the Australian Capital Territory is preparing to travel to a licensed shooting competition. They intend to transport their firearm to the venue, which is several hours away. Considering the legal obligations and best practices for firearm safety in the ACT, which of the following approaches best ensures compliance and safety during the transportation phase? Option A. The firearm is unloaded, the action is open, and it is stored in a locked, approved firearm safe or container, with ammunition stored separately and securely throughout the entire journey. Option B. The firearm is transported loaded in a locked firearm case, as the license holder plans to immediately use it upon arrival at the competition. Option C. The firearm is unloaded and placed in a locked firearm case, with ammunition stored in the same case but in a separate compartment. Option D. The firearm is unloaded and placed in a locked firearm case in the boot of the vehicle, while the license holder attends a social gathering before proceeding to the competition venue the following day. Correct answer is A. The firearm is unloaded, the action is open, and it is stored in a locked, approved firearm safe or container, with ammunition stored separately and securely throughout the entire journey. Explanation. This scenario presents a professional challenge for Category H firearm license holder in the Australian Capital Territory Act, due to the strict legal requirements surrounding the storage and transportation of firearms. The license holder must demonstrate a thorough understanding of the Firearms Act 1996 Act and its associated regulations, specifically concerning the secure storage of Category H firearms when not in use and the conditions under which they can be transported. The core of the challenge lies in balancing the convenience of having a firearm readily accessible for a legitimate purpose, e.g., a competition, with the paramount legal obligation to ensure public safety and prevent unauthorized access. The best professional practice involves adhering strictly to the legislative requirements for firearm storage and transportation. This means ensuring the firearm is unloaded, the action is open, and it is stored in a locked, approved firearm safe or container, separate from ammunition, during transit. The firearm should only be removed from this secure storage when absolutely necessary for the immediate purpose of the licensed activity, such as at the competition venue itself, and then immediately resecured. This approach directly aligns with Section 47 of the Firearms Act 1996 Act, which mandates secure storage to prevent unauthorized access, and the general principles of responsible firearm ownership that underpin the licensing framework in the ACT. It prioritizes safety and compliance above all else. An incorrect approach would be to transport the firearm in a locked case, but with ammunition stored in the same case. This fails to meet the legislative requirement for separating firearms from ammunition during transport, as stipulated by the Firearms Act 1996 Act and associated regulations, thereby increasing the risk of accidental discharge and contravening storage provisions. Another incorrect approach would be to leave the firearm unloaded in a locked case in the boot of the car while attending a social engagement, even if the competition is scheduled for the next day. This constitutes unauthorized storage and possession outside of the immediate license purpose and location, violating the spirit and letter of the law regarding secure storage and preventing access by unauthorized persons. Finally, transporting the firearm loaded in a locked case, even if the intention is to immediately use it at the destination, is a severe breach of safety regulations and explicitly prohibited under ACT firearms law, posing an extreme risk to public safety. Professionals should employ a decision-making framework that prioritizes legislative compliance and public safety. This involves 1. Identifying the specific legal obligations related to the activity, storage, transport, use. 2. Assessing the risks associated with different actions. 3. Choosing the course of action that most effectively mitigates risk and ensures full compliance with the Firearms Act 1996 Act and its regulations. When in doubt, seeking clarification from the relevant ACT authorities or consulting the official legislation is crucial. Question 18. Performance analysis shows a Category H firearm license holder in the Australian Capital Territory is preparing to transport their registered firearm to a licensed shooting range. They have unloaded the firearm and placed it in a locked gun bag, which is then placed in the boot of their car. The ammunition is in a separate, unlocked container in the passenger compartment. What is the most compliant method for transporting the firearm and ammunition according to ACT legislation? Option A. The firearm can be transported unloaded in a locked gun bag in the boot, and the ammunition can be in an unlocked container in the passenger compartment, as long as the firearm is not loaded. Option B. The firearm must be unloaded and in a locked gun bag, but the ammunition can be stored loosely in the boot alongside the gun bag. Option C. The firearm must be unloaded and secured within a locked firearm safe, and the ammunition must be stored separately and securely, with both the firearm and ammunition being transported in a manner that prevents unauthorized access. Option D. The firearm can be transported loaded in the locked gun bag, provided the bolt or action is removed, and the ammunition can be carried in the passenger compartment. The correct answer is C. The firearm must be unloaded and secured within a locked firearm safe, and the ammunition must be stored separately and securely, with both the firearm and ammunition being transported in a manner that prevents unauthorized access. Explanation. Scenario analysis. This scenario presents a professional challenge for Category H firearm license holder in the Australian Capital Territory Act, due to the strict regulations surrounding the storage and transportation of firearms. The core of the challenge lies in balancing the legal requirements for secure storage with the practical need to transport the firearm for a legitimate purpose, such as attending a licensed shooting range. Misinterpreting or neglecting these requirements can lead to serious legal consequences, including license suspension or cancellation, and potential criminal charges. Careful judgment is required to ensure all legislative obligations are met. Correct approach analysis. The best professional practice involves adhering strictly to the requirements outlined in the ACT's Firearms Act 1996 and associated regulations. This means ensuring the firearm is unloaded, stored in a locked, approved firearm safe, and that ammunition is stored separately and also securely. When transporting the firearm, it must remain unloaded and secured within the locked safe, and the safe itself should be secured to prevent unauthorized access or removal. This approach directly addresses the legislative intent of minimizing the risk of unauthorized access, theft, or misuse of firearms. The ACT Firearms Act 1996 mandates secure storage and transport to prevent harm and maintain public safety. Incorrect approaches analysis. One incorrect approach involves transporting the firearm unloaded but not in a locked safe, perhaps only in a locked vehicle boot. This fails to meet the ACT's legislative requirement for a locked firearm safe during transport, increasing the risk of theft and unauthorized access. Another incorrect approach is to transport the firearm loaded, even if it is unloaded from the magazine. The ACT legislation requires firearms to be unloaded, meaning no ammunition is in the chamber or magazine when stored or transported, unless specifically permitted for certain activities under strict conditions not applicable here. A further incorrect approach is to leave the firearm in a locked safe, but store the ammunition unsecured in the same vehicle. The ACT regulations require ammunition to be stored securely and separately from the firearm, even when both are in transit. Professional reasoning. Professionals should adopt a proactive and meticulous approach to firearm safety and compliance. This involves thoroughly understanding the specific legislative requirements of the ACT, including the Firearms Act 1996 and any relevant regulations or codes of practice. Before any transport, a checklist should be mentally or physically reviewed to ensure all conditions are met. Firearm unloaded in a locked safe, safe secured, ammunition stored separately and securely. When in doubt, it is always best to err on the side of caution and seek clarification from the relevant ACT authorities, such as ACT policing or the Firearms Registry.